Between December 2010 and March 2011, 4 individuals in Detroit, Michigan conspired or participated in armed robberies. In 2011, without getting a probable cause warrant, the government obtained several months' worth of cell phone location records for the suspects in the criminal investigation. For one of the suspects, Timothy Carpenter, the record revealed 12,898 separate points of location data, an average of 101 each day over the course of 4 months. The Supreme Court heard the case on November 29th of 2017. After Carpenter was convicted at trial to 116 years in federal prison, based in part on the cell phone location evidence, he appealed to the Sixth Circuit Court of Appeals. The ACLU filed an amicus brief arguing that the government violated the Fourth Amendment when it obtained the location records from Carpenter's wireless carrier without a warrant. The Fourth Amendment is, quote, "the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." End quote. One of the 4 men who confessed to the crime gave FBI his cell phone number and the number of the other participants. The FBI used this number to apply for 3 orders from a civil judge to obtain transactional records for the phone numbers, which the judges granted under the Stored Communications Act, which provides that the government can require disclosure of certain telecommunications when specific and articulable facts show. Stored Communications Act provides the rules that the government must follow in order to compel a third-party search provider to disclose customer or subscriber content and non-content information. The FBI was only granted to obtain transactional records, but was not granted a search warrant. Getting the search warrant requires the government to prove probable cause, which is harder to obtain because it requires more specific information. The 16 different phone numbers called or received by the confessed robber around the time of the robberies were not sufficient evidence to establish probable cause. Hence, the FBI did not get the warrant. Prior to Carpenter, government entities could obtain cell phone location records by claiming the information was required as part of an investigation. After Carpenter, government entities must obtain a warrant in order to access the information. The decision overturned portions of the 20th century legislation and case law when nearly all U.S. homes had landline phones in favor of constitutional rights stemming from technological advances of cell phones in the early 21st century. As technology advanced in the 21st century, the court began to back away from its 20th century third-party doctrine. The third-party doctrine is a United States legal theory that holds that people who voluntarily give information to third parties, such as banks, phone companies, internet service providers, and email servers, have, quote, no reasonable expectation of privacy.
Carpenter disagreed with using cell site data for evidence, and that it was against the Fourth Amendment. He also viewed that they needed a warrant to find evidence. The U.S. thought differently. Carpenter's cell site was business records. It was against the Fourth Amendment. The Supreme Court viewed that Carpenter had no reasonable expectations of privacy over data his own provider compiled for its own business purposes based on standard commercial transactions. When making a call, your phone sends radio waves to the nearest cell tower. When the tower receives the waves with its antenna array, it transmits the signal in telephone exchange for phones. This allows the call to be connected to other mobile phones or network. A wire or fiber optic line carries the call down to the wireless access point.